Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we got some big news, two pieces of big news, and it's good news. And this comes on the heels of yesterday's video about the case of Ortega v. Lujan Grisham, which found that New Mexico's statutory waiting periods were unconstitutional. Well, we have not one, but two cases, one from New York, one from Florida. We've gotten rulings on both of them. They are huge rulings, and we are really feeling some mojo right now. We are moving in the right direction. This has been a very positive week. So for all the times we got to talk about bad stuff, how we're getting punched in the mouth or kicked in the shins, it's nice to be able to do a video like this. So today, let's spend a few minutes and let's talk about a double dose of 2A good news. Okay, America, we are talking about not one, but two separate cases, both of which we got rulings yesterday, as you watch the video on the day that it's coming out, so it would have been yesterday. We got two huge rulings. The first case that we're going to talk about comes from the state of New York, and that is the case of Higbie v. James. This is out of the United States District Court for the Northern District of New York, and this is now a successful challenge to New York's concealed carry laws that basically said unless you're a resident of the state of New York, you don't get a concealed carry license anywhere in the state of New York. New York is not totally unique to that. Now, just to give you an idea of the statutory framework that was challenged here, the applicable law read, application shall be made and renewed in the case of a license to carry or possess a pistol or revolver to the licensing officer in the city or county, as the case may be, where the applicant resides, is principally employed, or has his or her principal place of business as merchant or storekeeper. Translation, you don't get to apply for a concealed carry license in the state of New York unless you live in the state of New York or do your principal place of business in the state of New York, which means if you are just traveling to the state of New York, a state which, by the way, has a lot of people that travel to it, there is no way that you can lawfully carry a firearm in protection of yourself and your loved ones. Now, I was not aware that constitutional rights just end at state lines, and typically they do not. Your right to speak freely, right to go to church, right to vote, none of that ends at a state line, but apparently when it comes to your Second Amendment rights, especially with states like New York and California and Hawaii, yeah, your rights end before you even enter that state. Now, you know the plaintiffs were onto something good here whenever the defendants raise as many roadblocks as they possibly can, trying to get the case resolved before they even get to the merits of the argument. So, of course, they were raising arguments like standing and 11th Amendment immunity and mootness. That's right. And whenever you see defendants trying to defend their laws based on that, what you're really hearing is, hey, don't pay attention to the man behind the curtain, because they do not want to get to the merits of the argument. Now, one of the biggest games that the state of New York played was the one of mootness, which is just a way of saying, hey, there really is no issue to be resolved anymore. We already fixed the problem. And where the state of New York was coming from is that there were a few counties that had started granting out-of-state carry permits, and therefore the issue was moot and the case should just be thrown out. The problem is that, as we know, with the state of New York and a handful of other states, they will do anything humanly possible, not only to win these suits, but to make sure that you're disarmed. And so while they may have implemented these plans in order to make the issue moot, there's no guarantee that they just wouldn't reverse course. And that ultimately led the U.S. District Court for the Northern District of New York to rule, a defendant's voluntary cessation of a challenge practice will moot a case only if the defendant can show that the practice cannot reasonably be expected to recur. At bottom, the rule traces to the principle that a party should not be able to evade judicial review or to defeat a judgment by temporarily altering questionable behavior. The other argument that the state of New York made, and they made this with a straight face, is, well, none of these plaintiffs had actually even tried to apply for a license because, well, they couldn't get one even if they had. And because they hadn't even applied for a license and gotten rejected, they didn't even have standing to bring this challenge. Again, the U.S. District Court was not impressed or convinced by this argument when they ruled. As explained, the Supreme Court and the Second Circuit have noted that plaintiffs should not be required to engage in futile acts before bringing a constitutional challenge. Now, the plaintiffs here brought both a facial and as-applied challenge. The facial challenge has failed. We will not get too deep into those woods there. But the as-applied challenge has, in fact, worked, because at the end of the day, the question is does the activity that we're talking about here, is it covered by the plain text of the Second Amendment, where we're talking about possessing a firearm for self-defense purposes? Clearly, the Second Amendment is implicated. Therefore, it became New York's duty to justify it through historical analogs. And shockingly, we don't have a history of terminating an individual's constitutional rights merely because they cross a state line. As the circuit court ruled, Defendant James admits that state licensing laws, such as the one the plaintiffs are challenging, did not emerge until the early 20th century. His argument that when similar laws did emerge, jurisdictions across the country regularly included in-state residency or employment requirements is unavailing. And the real problem for the state of New York, of course, was Defendant James has not presented any legislative history which supports restricting non-residents from applying for a firearm license in New York. Contrary to Defendant James' argument, an in-state residency or employment requirement for firearms licensing is not entirely consistent with this nation's historical tradition of firearm regulation. Not entirely consistent, it's not consistent at all, because once again, when it comes to both Second Amendment rights and any other constitutional right, they just don't seem to end when we cross state lines. Ultimately, the United States District Court for the Northern District of New York has ruled, given the lack of supportive historical tradition for restricting firearm licenses to out-of-state residents and the fact that plaintiffs are not otherwise exempt from carrying a firearm, the statute is unconstitutional as applied to the plaintiffs who were denied and prohibited from getting a license in New York. So, that is the first case that we got yesterday, and again, a huge win for everybody who has to travel to the state of New York and still values your life. Now let's go right down the East Coast there to the state of Florida, because we had another huge ruling in the case of Florida Commissioner of Agriculture versus Attorney General of the United States. This is a case that comes out of a 3-judge panel of the 11th Circuit, and this is a challenge, a now successful challenge, to 18 United States Code Section 922D3 and 922G3, which is the prohibition on those who use controlled substances from possessing a firearm. The issue here, and I think it's important that we narrowly define what the issue was, is all of the plaintiffs were medicinal marijuana users using under Florida's medicinal marijuana law. Now, the district court had originally thrown this lawsuit out, finding that cannabis users were not law-abiding individuals, nor were they even part of the people as contemplated by the Constitution. A 3-judge panel of the 11th Circuit, however, was not convinced, because they have ruled, upon review, we find the district court erred in granting the federal government's motion to dismiss because it did not view the First Amended complaint's allegation in a light most favorable to the appellants. When viewed in this light, appellants cannot be fairly compared with felons or those the government deems dangerous. Thus, the government failed to meet its burden at the motion to dismiss stage to establish that disarming medical marijuana users is consistent with this nation's history and tradition of firearm regulation. Now, the federal government had, of course, argued that, hey, these are potheads, and potheads can't be trusted. They're dangerous. They're unpredictable. They're not part of the people. The 11th Circuit 3-judge panel pointed out that, the worst case scenario we can come up with, legally speaking, for someone who is medicinally using marijuana, is that they could be in violation of misdemeanor laws in the state of Florida. And we don't have a historical tradition of disarming individuals for simple misdemeanors. As the court put it, following Higbie, we reject the federal government's argument that the plaintiffs are not among the people because they are not law-abiding and responsible. In Higbie, the Supreme Court explicitly rejected the government's contention that Higbie may be disarmed simply because he was not responsible. In doing so, the court explained that responsible is a vague term and that it was unclear what such rule would entail. And that is a big ruling that is consistent with Higbie, because the United States government has argued that if they can just label a person as irresponsible, and we have to understand what a catch-all label that could be. How many different types of individuals could the federal government shove underneath that label? Well, that would allow a significant amount of additional civilian disarmament. The three-judge panel of the 11th Circuit was not convinced at all, however. They have ruled. First, as discussed above, at most, the complaint alleges that the plaintiffs are committing a misdemeanor, not a felony, by using marijuana for medicinal purposes. The federal government has not pointed to any historical tradition of disarming those engaged in misdemeanor conduct. So despite the fact that the United States government fought vehemently to uphold this law, they were not successful because a three-judge panel of the 11th Circuit has ruled. Based on appellants' factual allegations, appellants cannot be considered relevantly similar to either felons or dangerous individuals based solely on their medical marijuana use. Accordingly, the federal government has failed at the motion to dismiss stage to establish that disarming appellants is consistent with this nation's history and tradition of firearm regulation. Thus, we vacate the district court's order and remand for further proceedings consistent with this opinion. And listen, as a practicing lawyer, I really do love consistency in the law, consistent application of law. And I think that there is very clear law out there that people cannot be in possession of firearms while they are actively under the influence of any type of controlled substance, legal or otherwise. I have zero issues with that. Lawful and responsible gun ownership mandates exactly that. But why should a person be disarmed 6 days a week because on the 7th day of the week they want to go home and smoke a joint, either for recreational purposes or in this case because that is what the doctor has told them to do? So listen, America, for all the times that we spend here on this channel complaining how we just got punched in the mouth, kicked in the shin, or kneed in the groin, we have now had 2 days in a row where we have had huge wins which advance our Second Amendment rights. We had the 10th Circuit strike down statutory waiting periods just a couple of days ago. And then yesterday, we have both New York's crazy concealed carry licensing law, which only permits New York residents to apply for that license. That gets struck down, as well as a successful challenge to 18 United States Code Section 922 D3 and G3, which again is a huge advancement for the Second Amendment rights of all of those medicinal marijuana patients in the state of Florida. Okay, listen. We're going to go ahead and link up both of the cases that we talked about here today so that you can geek out on them for yourself. You don't have to take our word for it. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They paved the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.